And that's when new law is made, and that's when we get new decisions. And it would be very interesting to see if ultimately a court would say, hey, you know what, felons at some point can possess firearms.
We are the Armed Attorneys. Today we're talking about an important decision out of the 10th Circuit Court of Appeals and how this could affect 18 U.S.C. 922G, tearing down the prohibition on felons in possession of firearms. But before we begin, show your support for the Second Amendment by hitting that like button. And today's video is brought to you by our friends over at Sonoran Desert Institute. Check them out at sdi.edu/armed-attorneys and our friends at Aura. Anyone can find anything on the internet, including your full legal name, your personal email, your home address, phone numbers, and even your relatives. I tried it out myself. I Googled one of my sister's phone numbers and immediately found her home address. And that's pretty scary because she's a former prosecutor and that information is supposed to be concealed. But that's because of data brokers who profit by selling your information to robocallers, telemarketers, spammers, and anyone else that wants to learn more about you. That's why I'm excited to tell you about our sponsor, Aura.
Aura will identify data brokers that are exposing your information and automatically submit opt-out requests on your behalf. They'll even opt you out of junk mail and telemarketing lists.
You can use our link aura.com/armedattorneys to try 2 weeks to see how many data brokers are sharing your information. It's also linked in our description below, or you can scan the QR code. Aura also monitors your emails and passwords to see if they were involved in a data breach and exposed on the dark web, and it gives you recommendations on what to do. Aura's app also features a VPN, password manager, real-time credit and identity theft monitoring, internet parental controls, and protects your devices from malware. Aura has almost every internet safety tool you'll ever need, all inside one app. So let Aura do the hard work for you by keeping you safe online. If you sign up right now, Aura will give you 2 weeks free with our trial link. You'll be shocked at how much of your private information Aura finds exposed over those 2 weeks. Go to aura.com/armedattorneys to start your free trial, also linked in the description, or scan the QR code. So this is a hot off the presses decision. Leslie Cross, thank you for joining us.
Sure.
This landed September the 15th. So, I mean, this is just a few days ago. And what are we talking about?
Today we're talking about a case from the U.S. District Court, the District of Utah, and it's the 10th Circuit Court, which includes Colorado, Kansas, New Mexico, Oklahoma, Utah, and Wyoming. And the case is Vincent v. Garland. And this is a case where a convicted felon actually is appealing to try to get her gun rights back. Ms. Vincent was convicted of a nonviolent felony. She was convicted of bank fraud. And because of that felony conviction, she is never eligible to own or possess a firearm or ammunition ever again. So initially, the court dismissed her claim, saying that she had failed to state a claim. And the U.S. Court of Appeals actually affirmed that.
And so this case is significant for a couple of reasons. One, I think it's extremely illustrative and something that folks in the gun community need to be aware of how these courts will do anything to beat around the bush and to not be held accountable, for example, under the New York State Rifle and Pistol Association v. Bruen standard, how they'll go way out of their way to avoid this stuff so you can anticipate these arguments. But also, I think what is also very significant is now we have 2 circuit courts of appeal that are disagreeing when it comes to possibly felons possessing firearms. We have something out of the 5th Circuit Court of Appeals, and that was a facial and as-applied challenge. They found that for that particular person, because it was a nonviolent felony, hey, you get your gun rights back. But going back to the case here, the court first did an incredible thing. I mean, they affirmed, like you said, but the way they got there, they said, first, we are bound by our own precedent, and we say and have upheld felon in possession of firearms laws. Second thing that they're looking at and how they're analyzing this is our previous precedent, which we decide that we're bound to, was it contradicted by New York State Rifle and Pistol Association v. Bruen? And what did they say to themselves?
Basically, they said that did not go against their precedent. And because it didn't go against it, they were going to uphold their own precedent, and they didn't have to look at this in any other light.
Yeah, and I could see it in your eyes. This is not Leslie's favorite thing
Correct.
to talk about.
No, I hate talking about this stuff.
When you hear, I heard you say precedent 3 times in a row. I could no. This is not Leslie's cup of tea.
Correct.
Leslie likes to be in the courtroom.
That's correct. Yeah, put me in a courtroom and let me argue to a jury. That's what I like.
But I think it is important, though, because, and this is what the court kind of hangs their hat on, because they're saying, first off, have we contradicted ourselves, or has the Supreme Court contradicted our opinion in United States v. McCane? If you want to check that out, that's 573 Fed 3rd 1037. They rely heavily on, well, look, Justice Kavanaugh in a concurrence cited Heller, and Heller talks about felons not being allowed to possess firearms.
Here's what the quote says: "Nothing in its opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by a felon, and felon disposition statutes are presumptively lawful."
Yeah, but you think about the inception of how we got here, because that's partially from Heller.
Hmm.
They're quoting Heller in New York State Rifle and Pistol Association. It's in a concurrence. And so we see, when this court looks at New York State Rifle and Pistol Association v. Bruen, they see 6 justices don't really are on board with that. They reaffirm the language in Heller, and so therefore they're going to leave it undisturbed, and that's how they get and say, hey, look, a felon isn't allowed to possess a firearm. But I think the significant thing about it and what folks need to take home from this is the circuit split.
Right. And that means that it could go up to the Supreme Court, and that's when new law is made, and that's when we get new decisions. And it would be very interesting to see if ultimately a court would say, hey, you know what, felons at some point can possess firearms. And me personally, I mean, I think at some point, if you are convicted of a non-violent felony, let's say that you had less than a gram of cocaine when you were 18 years old and you're now 56 years old, I don't see any reason that you shouldn't be able to possess a firearm and defend your family. I mean, something that you did at 18 that doesn't say that you are a violent person or something like that. I just don't see how you should be held accountable your entire life for potentially a mistake that you made when you're 18, 19, 20, 21 years old.
Yeah, because they completely sidestep the test, which they're supposed to use is this conduct covered by the Second Amendment? Yes. Well, the government, the burden should be wholly on them to demonstrate based on the text of the Second Amendment, based and informed on history and tradition, that this is the type of regulation that would have existed at the time that the Second Amendment was adopted in 1791. We don't have any of that. And so I think it's going to make for an interesting discussion. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And we always appreciate your questions and comments in the section down below. And until next time, we're the Armed Attorneys.
Okay.
Or do you want me to read that part?
Sure. Wait, I gotta stop laughing.
Do you have anything to add to that?
Nope. If you want me to say something, I'll say it.